Hello, everyone who's joined. We're just waiting for the remainder of the attendees to join, and then we'll get started. Okay. Given that we only have an hour, we're going to go ahead and get started. We have about a third of the attendees. But we want to make sure that we respect everybody's time. So hello, my name is Kristin Lindgren-Bruzzone. I'm the general counsel for CSBA. Thank you all for being here today. I have with me some great attorneys from F3 Law who helped write the amicus, or did write the amicus brief on this matter. So I'm going to kick it over to them to introduce themselves. Peter, please go ahead.
Thank you, Kristin, and thank you all for joining us. It's an exciting topic. Just by way of introduction, Peter Fagan with the firm F3 Law, Fagan, Friedman, Fulfrost. And when CSBA asked us to put together this brief, we had put together a great team. Gretchen and I were the two people that actually went to the Supreme Court and for the oral argument, and were there. But two other partners need to be mentioned: Christopher Keeler and Lynn Beekman, who also played significant roles and carried a heavy load in putting this brief together. So again, Kristin, thank you for the opportunity. And I don't think I need to introduce F3 Law. I think most people here probably have heard of us. We're an education law firm in California, and love working with you all. Gretchen, why don't you tell a little bit about yourself?
Thank you. My name is Gretchen Shipley, and I'm a partner at F3 Law, and I chair our practice dedicated to education technology. And this case presented a really exciting opportunity to weigh in on the challenges that both school board members and school administrators face as it applies to social media, as we advise a lot of school districts on social media management and training on that topic. So we are really excited about the opportunity, and we think the decision that we're going to discuss today was a big win for school districts, and a really honored to be a part of it. And again, I extend my thanks to CSBA for that opportunity.
Okay. Thanks to you both. So just a few housekeeping matters. If you could turn to the next slide, please. Our wonderful comm staff is helping us out today. So just a few things. Please hold your questions to the end. We'll have a question and answer segment. Well, we'll do the best to answer questions in the time allotted. If we see a lot of duplicate questions, we'll just collapse them all into one question and answer it that way. Please use the Q&A feature and not the chat. If you use the chat, we might and probably will miss your question. But please use the Q&A feature. It's located on the ribbon below the speaker. And we have a little diagram there that shows where to look and where to find that Q&A section. We'll either answer the question in the Q&A box or we'll answer it live. You will receive a copy of the slide deck and the recording after the presentation. So just be aware that those are available to you, and they will be sent automatically to the email that you registered for the webinar. So let's get started with the content. Next slide, please. So our objective with this webinar is listed here on this slide. The main takeaway is for us to help you understand the standards set forth by the U.S. Supreme Court in the O'Connor-Ratcliffe versus Garnier case, regarding school board member use of social media. And Peter and Gretchen will get more into the facts of the case, but I'm sure you all know that this was a lawsuit that was brought in response to two school board members in the Poway Unified School District blocking members of the public on their private social media accounts that they had used to discuss district and board information. The ELA, CSBA's Education Legal Alliance, kind of took a unique step in this case because we thought the case was so important. Typically, we file amicus or friend of the court briefs on cases of statewide importance to school boards in California only if we receive a request to do so. We did not receive a request in this case, but because of the importance of the case, we decided to go ahead and file an amicus brief anyway. And our steering committee agreed to do it that way because we thought that this case was so important. We had a number of policy concerns regarding the case, including that the Ninth Circuit, which was the lower court, had really created a test for determining whether a board member is speaking on behalf of the district and engaging in what's called state action. That was far too broad and would encompass far too many activities, private activities of board members, and negatively impact their First Amendment rights to speak on issues that they think are important. And so that was the main thing. We do also think it's important, as Gretchen mentioned, to get involved in cases around new technology and social media, because many of those cases, and this case is no exception, are cases of first impression where we don't know the answer. The Supreme Court has not weighed in yet. And so it was very important to once the Supreme Court decided it was going to weigh in, to make sure that we made that CSBA members' voices were heard in this matter and how it would affect school boards going forward. We noted a number of impacts, and one that was really important is that we know that school board members have to speak with one voice as an entire board. And what the Ninth Circuit's decision did was create a scenario where one board member could be seen as engaging in state action and having the imprimatur of the board to speak on behalf of the board, which is not how it works. And so we wanted to make sure that the court understood the negative potential outcomes and the uniqueness of how acting as one board versus as individual members is impacted these facts. And at the end of the day, we also wanted the court to tell us, hey, if you're going to find that we're acting as a state actor in these social media activities, is there a way that we can have a disclaimer or some other sort of regulation that will help us avoid liability? And so Peter and Gretchen and their team did a really great job in the brief arguing that we needed something like that, and the court listened and also discussed that, which was, I think, really helpful to get practical advice from the court. We don't always get that. Next slide, please. So the key takeaway here is that board members can take steps to establish a personal, not official social media page, exercise their First Amendment rights, and do so in a way that does not subject them or their district to liability. And there are some caveats here, and Peter and Gretchen will go through what a disclaimer might look like that would help avoid liability, some things to watch out for, and some other pieces that you still have to be cautious about, even though, as Gretchen notes, we consider this a really big victory for school boards. Next slide, please. And I'm going to kick it over to Peter.
Okay. Thank you, Kristin. Just before I get into this two-part test, really the importance of this webinar is that we've spent the last 2 years as a result of the Ninth Circuit decision providing governance training and social media training for board members based on the Ninth Circuit's decision and interpretation of the way they thought the court should go. Obviously, the Supreme Court came down in a different position And so it's important that all board members who have received the training over the last couple of years and have been told that you can't block people, you can't hide comments, and that you have created you're acting on behalf of the school district or the state, taking state action is the way they put it. And now that's changed. And so it's important for us to make sure that that everyone understands that. The interesting part about this, well, there's so many interesting parts about this case, but the holding of the case really created a two-part test. And the court was really trying to come up with one test that would apply to all public agency members or public officials or elected officials. And that was clear during the discussion and the argument on the case. And some of the justices were talking about, well, how would this apply to the Trump case? And so you're talking about school board members and you're talking about a president. And then the Lindgren case, which was a city manager case, and they were all being kind of lumped in together. And so I was hopeful going into the Supreme Court that they'd come out with a simple test for everyone. But after the hearing, I walked out of there and thought, there's at least 5 or 6 different tests going on between the 9 justices, and I don't know that they're going to be able to come up with one. But they did. And Amy Coney Barrett drafted the opinion, and she put together a 2-part test. And the 2 parts are: 1, does the public official have authority? And this you have to have number 1 in order to get to number 2. And for school board members, I think this is going to be the hardest one to get, or the easiest one to say. I don't have the authority, because as we all know, school board members, unless you're the board president or someone in very different and not so common circumstances, you don't have authority to act on your own on behalf of the school district. As Kristin said, you're one of a group. There's a group authority, but there's not individual authority. A school board member can't speak or act or give direction on their own. That only happens by the school board at a properly noticed and appropriately agendized meeting. So does the public official have the actual authority to speak on behalf of the school district? Generally speaking, school board members are not going to meet that test, that first prong of the test. But then if you are, part 2 of the test then comes in, and by your speech or action, your use of the social media, you're purporting to exercise that authority. So that's the 2-part test. And the interesting discussion that the justices had was, and the reason they had so much trouble, I think, during the oral argument, kind of coalescing behind what appeared to be an argument or a position or test that they would go to, was that there were First Amendment issues on both sides of this case. The First Amendment issues of the public being able to address the public officials, as well as the First Amendment issues of the public officials being able to exercise their First Amendment rights and not lose them just because they were elected, which we will talk more about a little bit later in this webinar. So with that, we'll move on to the next slide, and Gretchen can tell us how we got here. Give the background, and then we'll really get into the nitty-gritty.
Thank you, Peter. And as you mentioned, I think it's the reason we really wanted to present to you all today is that the legal advice that's been provided for the past 2 years has changed. There's a new law of the land, and it's important that as school board members, or even as school officials who advise school board members on their social media use, that everybody clearly understands what that 2-part test is and how it can be applied to their social media. But really, to understand how to apply it, it's helpful to revisit where we've been and how we got here. So factually, for those of you who might not recall, there were 2 school board members, O'Connor Ratcliffe and Zane, they started social media pages before they were elected to the board. And they did so, they included personal content and campaign content. Then they were elected to the board, and they continued to use those same social media pages to post about district business, things happening recaps of a board meeting. Maybe there was a vacancy on their Citizens Bond Oversight Committee. And what happened was that community members who were critical of these two board members would post comments. And sometimes it was as many as 226 identical replies within 10 minutes. And that's the trendy word for that is spamming. It would fill up your entire feed, rendering your social media page pretty useless, frankly. And so whether it was critical comments or it was spamming, they decided to, at first they blocked those comments and then they turned around, I'm sorry, at first they deleted those comments and then they turned around and blocked these community members altogether. Well, those community members filed a lawsuit in federal court, and the district court decided that no, actually those community members had a free speech right to spam and troll their social media page, and that those school board members should be prohibited from blocking and deleting that content. And that decision was upheld by the Ninth Circuit Court of Appeal when it was appealed by the school board. And so the result was, and what we've been telling people over the past couple of years is, well, if you're a public official and you're talking about district business, you've now created a public free speech forum, and you're going to have to tolerate any sort of derogatory comments, or, not protected free speech, but things like that are critical or the spamming. And the result was really a challenge for board members to navigate, especially if you're running for a re-election campaign. Of course, you're going to want to go on and talk about all the great things you're doing for your school district, but how are you supposed to have a bunch of criticism up there as well, especially if you have an incoming opponent who doesn't? So the way to apply it was frustrating and challenging. And that is really why we felt it was important, CSBA felt it was important to try to argue a practical impact approach and a legal argument, of course, to the Supreme Court. And the test that they have come out with is much more clear and gives back a lot more control to school board members on what content they can put up on their social media page, but also when when are they obligated to friend somebody? When can they delete a comment? When can they block somebody? You have a lot more discretion now. So I do want to have the caveat, though, that the actual case as it applies to the two board members is technically on remand from the Supreme Court, which means the Supreme Court issued a new test that is the law of the land and it applies to all you school board members, but they sent the case back down to the Ninth Circuit to say, okay, Ninth Circuit, I want you to apply the new test to these two individual board members. So there may be another decision coming out from the Ninth Circuit, but we don't anticipate that the test will change from the Supreme Court. So hopefully that kind of gives you some background and understand how we arrived at where we are today. Peter, back to you.
Okay, next slide. This was such an interesting case. And I was so glad that we were able to go to the Supreme Court for the oral argument. Just a little bit of a story about it. There were two cases, there were companion cases that were heard the same day, the same morning, actually. The Garnier case that we're talking about and the Lindgren versus Freed case, which came out of the Sixth Circuit. And the reason this wound up at the Supreme Court was because of the Sixth Circuit in the Lindgren versus Freed case had come to a different decision than the Ninth Circuit did in the case that we're talking about. Obviously, the Ninth Circuit said board members speaking about their duties or their thoughts or about their school board member activities with state action. And so you could not prohibit anyone from commenting or following you. But the Sixth Circuit ruled the other way and basically said that so long as the social media page wasn't sponsored by, supported by, funded by the public agency, it remained private, and the city manager in that case was able to block people and prohibit them from commenting on his social media posts. And so because of the conflict in the circuits, that's typically why the Supreme Court will take up a case, is to make sure that there's a uniform law of the land across the country rather than having different circuits with different tests or different decisions. So those two cases were heard back to back. And one of the funny things that I thought anyway was that during the Garnier case, a lot of the justices were talking about the Freed case, and they were conflating and confusing the two because it was obviously they put them on for the same day because of the conflict in the circuits, and they wanted to come up with one test. It appeared that there were going to be 5 or 6 different possibilities because the justices were all over the place. And some of them were asking rather bizarre questions. But then Amy Coney Barrett, who sits clear down on the left end, the side of the bench, started asking some questions when it was her turn, and they have kind of an informal order in which they go. And her questions really zeroed right in on what appeared to be the main issues here and where the decision came down. She kept asking about authority. This is about authority. Does the poster on social media have authority? And if they don't have authority, then how can that be state action? And I didn't feel like the oral argument really fleshed that out, but then once we saw the opinion, obviously it was something that she was able to get the rest of the justices to jump in on as well, because it was a unanimous decision. I walked out thinking this could be a 5-4, 6-3, and I don't know which way it's going. And then we get a unanimous decision, which I think is really powerful because it brings both sides of the spectrum together and says, this is the way we want you to operate. And as Gretchen said, both cases were remanded. And so they've gone back to the 9th Circuit and the 6th Circuit to have the facts of those cases looked at in light of the new test. And the new test, as I mentioned before, is does the public official have the actual authority to speak on behalf of their agency? And if they do, are they purporting to use that authority? And if those two are met, then it is considered a state action. I mentioned earlier that the First Amendment was at play on both sides, and several justices actually spoke about that and said that the reason they were struggling with it is that the First Amendment is at play here, and no matter how we come down, we're going to be possibly inhibiting someone's free speech. And the First Amendment, as many of you probably know, we consider it the Free Speech Amendment. There's several other things, but freedom of speech, the freedom to petition the government for redress of grievances, which is the argument that Lindgren was making, and I guess arguably in the California case as well, that you can't stop people from addressing their public officials because that would inhibit their right to petition government officials for redress of grievances. The other thing, part of the First Amendment, is a recognition of a freedom of association, a right of freedom of association. And when the court ruled that the public officials are exercising their First Amendment rights by either blocking or hiding comments or blocking individuals from their social media posts, they are exercising their First Amendment rights, which includes the freedom of association. And originally, I thought there'd be 2 tests, one for positions that have inherent authority in them, like a president or a governor or a mayor, who with the election to a specific position, you have authority already. And so you meet the first test. The first prong of the test, and then the next part would be, are they acting and using that authority at the time they're speaking? But Amy Coney Barrett and the Supreme Court came up with a 1 test for all, but it was a 2-part test. And so the same test applies to people with inherent authority in their position as applies to school board members who don't have any inherent authority in their position, because the authority rests with the board as a whole. And the board as a whole only acts at a properly noticed and appropriately agendized meeting through its majority. Another interesting thing, I think it's up, it's on one of the boxes on the slide, is that Amy Coney Barrett is the only member of the Supreme Court that is a former school board member. And so I think maybe that's why she kind of zeroed in on the heart of the issue in her questioning. And that's probably another reason why possibly the Chief Justice gave her the job of writing the opinion, because she had actually sat in the chair of a school board member and had a better feel for it than any of the other justices. So with that, I'm going to
Peter, can I mention a couple additional insights?
go right ahead.
that just came to my mind is some big picture concepts that I thought were also really interesting is the Supreme Court. This is their third. They have several social media cases recently. That's an important issue, and free speech. So this case addressed free speech for board members and school officials. There also was a recent social media free speech case specific to students addressing Snapchat. And then there was, it wasn't social media, but there was also a teacher-based free speech case. And so the Supreme Court in general is really leaning into free speech rights. The second thing I just wanted to mention was I was really surprised at the level of interest in this case by, we had states who filed briefs, but also the United States of America filed a brief on behalf of on the side of the school board members, and the Solicitor General of the United States requested to take over oral argument. And so it just demonstrated what an important issue, even though this started with 2 school board members based here in San Diego County, it really evolved to impact such a broad level nationally. And so anyway, I just thought I'd share that how critical this decision really was.
That's great. Thank you. And moving on to the next slide, it's the impact of disclaimers. And I know Gretchen's going to talk about this.
Absolutely. Can we advance one additional slide? I'm going to do them in backwards order. Thank you. So one thing that Justice Coney Barrett mentioned was that if there had been a disclaimer on the social media page, it would have created a presumption that that page was personal and not the official speech of the school district, or it would not be considered state action. And again, if it's state action, you're limited in how much you can control your page. So what they created essentially said, if you have a disclaimer, it's what's called a rebuttable presumption that it's in fact personal. So as we'll show you in a minute, we have recommended disclaimer language if you're going to be, if you have a social media page that is either personal or is mixed use. It's both personal and you might talk about district business. So it will be, if you have a disclaimer, it is presumed that it is personal to you. It is not state action. It is not on behalf of your school district, but there are 2 factors that could refute or eat away at that presumption. And one is the information on your page only available on the board members page, or are you simply restating things that might be on your district social media page? So if it's only available on your page, it looks more like official district speech that is, you know, creates this state action or a public free speech forum. The second one is if the school board member is actually using district resources to, you know, if you have somebody in your office who's actually doing your social media for you, then that also, I guess now as a school board member, if you're using some of the district office, not your personal office, your district office to do your social media, that also can eat away at that presumption that it's personal. But if we could go, the exact language the court quoted was, this is the personal page of James Freed. That was that companion case, Linke versus Freed, or these views are strictly my own. And the court quoted that. So we took that language and have created a sample disclaimer language that you all may want to consider putting on your social media pages if in fact they're intended to be personal and not intended to be official speech of your school district. So if you all could actually reverse one slide, we can go over what that sample language looks like. So the first one is a sample disclaimer that a school board member could use, and it basically just says it's the personal page of Gretchen Shipley. It's not sponsored, supported, or funded by anybody else but me. The views and opinions here expressed are my own, not intended to represent the position of school board member of the school district or position of name of your school district, or its board. So that is what a school board member might want to put up there. And I think what Peter's going to talk about in a minute is there's also implication for maybe school superintendents and other public officials, maybe members of cabinet. We're going to talk about how this case applies to them. So we went ahead and included disclaimer language that a superintendent might want to use on their social media page. And it's really the exact same, except the very end references or the public agency that I serve. And then one practical implication that we ran into is we understand that social media pages have character limits. So we did a abbreviated disclaimer that we also think could be used and would be helpful. So Kristin, it's my understanding that this slide deck is going to be made available to the attendees if they want to use this language. And this is just our recommendation. This isn't the exact, quote from the court or anything, but we think based on the language in the decision saying that a disclaimer creates a rebuttable presumption that it is your personal page or personal speech or personal opinions, we thought this would be helpful to meet that standard. Peter, I'll turn it over to you.
Advance it a couple of slides up to the companion case, and then I'll jump in from there.
Great.
And the companion case, we've mentioned it several times already, the Lindgren versus Freed case, which came out of the Sixth Circuit, which allowed the Ninth Circuit case, created the disparity between the two circuits that allowed it to get to the Supreme Court. On the disclaimer, the exact language from the case says here, if Freed's account had carried a label, for example, or e.g., quote, this is the personal page of James R. Freed, close quote, he would be entitled to a heavy presumption that all of his posts were personal. And I think that's really key language because she doesn't just say it's a rebuttable presumption. She does say that later, but she says he's entitled to a heavy presumption that all of his posts are personal. And so I don't think we can overstate the importance of adding a disclaimer like that because it will create a heavy presumption that everything you do on that page is private and is not considered state action or action of the school district. And therefore you would still be able to control that page. But again, you'd have to look at each post. And this is one of the things that came out of the Lindgren case is that you have this two-part test that we talked about. One is, does the public official have the authority to speak on behalf of the entity, the public entity? And I'll use school board. Does the school board member have the authority to speak on behalf of the district here? That's the first test. And then the second part of the test is, and are you purporting to do that? And if you put that disclaimer on there, it's very, I think it would be very hard. It'd be a unique situation, I guess I should say, where an individual board member who's not a board president who has not had specific authority granted to them by the board majority, that they would ever meet that both prongs of that test, and their statements would be considered state action. So what came out of the case, though, is that it's a post by post analysis, not necessarily a page by page analysis. So your social media, each one of your posts will have to be run through that two-part test. Now, granted, I don't think school board members are going to meet both tests very often, although there are some scenarios where that might happen. But about the Lindgren versus Freed case, James Freed was the city manager of Port Huron, and he started his Facebook page back in 2008 before he was a city manager. He became city manager and he continued to use the Facebook page, post pictures of his family and his kids and his dog and trips and that kind of thing. He became city manager, and then during COVID, he started posting some information about city regulations and what was going on in the city, which he was a city manager. And he was not even a strong city manager's position because they had a strong mayor position in that town. So he didn't have the authority to act on his own, but he was sharing information that came either from the mayor or from other city websites or information shared through other city channels. And the court even said that his page was about 90% personal and 10% related to his job duties as city manager. And for that reason, I think the Sixth Circuit ruled that because it wasn't sponsored, funded, or supported by the city, that it wasn't state action. And now on the board member side and the Garnier case, the percentages were a little bit different, but they've created the same test. And basically, any information that Mr. Freed was sharing was available somewhere else. And he did his own posts, which goes to the 2 points that Gretchen mentioned, is how you overcome the rebuttable presumption or heavy presumption, as the court said, that this is a personal or private page, is if you have someone who's on the payroll of the agency doing the posting for you, so you're using funds and or support from the agency, and you're providing information that is, it's the only place members of the public can get it, is from your social media page. If that's the case, then there's a good argument that the presumption would be overcome. The individual authority versus group authority is really important from a school board member context, because we've mentioned it several times. A school board member, once they're sworn in, when you're campaigning, you're an army of one. You get to call the shots. You're running everything, make all the decisions. Once you're sworn in and you're part of the group, you don't have authority to do that anymore. What you really have is the power of persuasion to try and convince a majority of your colleagues on the board to your point of view. And so that's the group authority is where it rests, which is why it's going to be hard for school board members to meet both prongs of the test, unless, and I have a scenario, and I'll just give you one scenario where it might happen, or I guess I'll give you two. One is a school board member. You may have board policies where the school board president is granted certain authority to speak on behalf of the board or the district in certain situations. That may be in your board protocols or actually in your board policies. And if that's the case, then the school board member meets the first prong of the test. The school board president meets the first prong of the test because they have the actual authority. And if they're speaking on behalf of they purport to use that authority by saying, on behalf of the school board, I'm announcing such and such. As for a non-board president school board member, it's not that it won't ever happen. It's just, I don't think it happens very often. But the scenario that I thought of where I've seen this was there's a school board that had a board member who was an expert basically in cybersecurity. And so that school board, the board itself, appointed that individual board member to work with the company that they were having investigate and test and provide training on cybersecurity for the school district, and the school board wanted to have a say in that. And so they appointed that individual member to be the board representative there. And so that was action taken by the majority of the board at a properly noticed and appropriately agendized meeting. And then if that board member, and I'm not saying this happened, but if that board member would then have a post on Facebook that says, on behalf of the district, I want to thank whatever the company is that did the training and the testing, and makes an announcement that the cybersecurity testing, the district has come through with flying colors, and whatever information they want to say, that looks to me like it's met both prongs of the test. One is they have the actual authority because the majority of the board gave it to that person. And two, he or she is purporting to exercise that authority by their post saying, on behalf of the board, I want to do whatever it is they're saying. So that is a scenario where a school board member could meet both prongs of the test, and then that action would be considered to create a public forum, be state action, and then you would no longer be able to hide comments or prohibit people from following. And again, as I want to make sure everybody understands, because the opinion says it's a post by post analysis now. It's not just take a glance at your Facebook page or your Twitter feed or whatever and say, oh no, that's private. It's a post by post analysis, but if you have the disclaimer, it's a heavy presumption in favor of it being personal and private, not public.
Peter, I
Kristin,
want to
yeah.
take one of the questions in the Q&A right now, just because I think that it's a good illustration of a question that might come up that we might not be able to answer the way that it's presented because it's a post by post analysis. So the question is, I have a personal social media, which I keep completely separate from my role as trustee, and also a trustee Jones social media. My trustee social media is paid for entirely by me with no connection to the district. I put a disclaimer on my trustee social media saying that the opinions are my own, and I'm not speaking on behalf of the district or the board. Can I block people on my trustee social media? So this is a very specific hypothetical, and I think that it is hard to answer because it would depend on still what is in each post. So the disclaimer is really helpful and useful and may provide that protection, but it's hard to know and we can't give a one and done answer on this question because it would depend on the factors that you just talked about in that scenario. So anything else you'd want to say about that, Peter or Gretchen?
Yeah, I'll jump in on this. I think Gretchen probably will as well, but she and I were talking about this before the webinar, that you hear things out there just saying, well, the easy thing to do is have a private page and a public page and just never the twain shall meet. But then you get a question like this, and if you put a disclaimer on your public page, does it create the same heavy presumption? Well, I'm not sure that it does because you've called it the public facing page and your public official page. So by calling something your public official page, I think you're undermining the disclaimer already by saying, no, I'm speaking as the public official here. You may not meet the two-pronged test on each of your posts, but I really am struggling with that, whether or not having the public page. If you have a public and private and you say one's public, then you're in essence undermining the benefits of the disclaimer that you put on to say, no, this is my private page and the views are my own. So I think I can see how they might cancel each other out. But again, it comes down to each specific post is what the court said will be analyzed to see whether or not the individual had the authority at the time of making the post and was purporting to exercise that authority with that post.
So Peter, in applying that two-pronged test, what I thought was interesting is they clearly meet the second, it's the second prong that's giving conflicting information. They're identifying themselves as, this is the page of trustee Jones. I am purporting to use this as my public facing school board member account. And then the disclaimer kind of cuts against that. But the first prong is also, did they have the authority? And so I think that's an important question here too, is whether or not this person actually had the authority to speak on behalf of the school district. I also wanted to mention on this Linke-Fried slide, the potentially different result this could have for superintendents and other members of cabinet. So, you know, we went into this on the Garnier case with CSBA, really focused on school board members. And, you know, that's the thrust of this webinar today. But Linke, as a city manager, is more akin to a superintendent who's not a member of a 5-person board, is may have the actual authority granted to them to speak on behalf of the district, and may have a superintendent facing page. And so that two-part test still applies to them. Do they have the authority, and are they purporting to speak on behalf of the district? And if so, that is going to be a public account. Now, they still may want to use the disclaimer, as we mentioned, because there's these cases where superintendents talk both about their activities at the district and their personal business. But I think it's going to be harder to overcome when you're an individual superintendent than it would be when you're a member of a board.
Right, and I think that ties in. I mentioned president, governor, mayor. I didn't mention superintendent, and thank you for Gretchen for bringing that up, because the superintendent, where is that authority coming from? It's some of it may be statutory, some of it may be contractually, because many superintendent contracts lay out what their responsibilities are as CEO of the district. And so it appears anyway on the surface that that first prong of the test would be much easier met by a superintendent than it necessarily would be by an individual board member. Then you get into whether or not members of the cabinet have any authority. So assistant, your CBO or your HR person, they may have some specific authority in certain areas as well. And then the question is, are they posting about that? Which under this case, they have the right to do, because as a public official, whether elected or appointed, they don't give up their First Amendment right to talk about what they do at work. And that was a good portion of the oral argument, is that people talk about what they do at work. And we're not going to tell public officials or public employees that just because you're a public official or public employee, you can't talk about what you do at work like everybody else can. So it just comes down to the context of where you're doing it, and whether or not you meet those two prongs of the test.
And I see we have really great questions coming in. Kristin, do you want to turn to the next steps in the Q&A?
We can go to the next slide, please. So just some next steps to think about as you address this case, and also just remember that we still have to hear from the Ninth Circuit on what happens to the particular board members at issue. CSBA will of course update you when that comes down. But some things to think about is reviewing your bylaws based along the points that Peter and Gretchen made about the fact that if your bylaws authorize anyone to be the speaker on behalf of the district, and I believe our sample bylaw does with the board president, be aware that that could cause that person to meet the first part of the test, that they are given the authority by the district to speak on behalf of the district, and could affect the outcome of whether they can block someone or any other piece of their use of social media. So we are also, as an organization, looking at that sample bylaw in light of this case and whether we should make any changes to it. So we will update that if it is necessary. But just keep in mind that one of the things that the court talked about is that authority to speak on behalf of the district has to come from some official place, and that could be your board bylaws or board policies. Make sure that if you are using social media for board action, that you implement a disclaimer. You may want to run it by your district legal counsel before you use it, but we really recommend the disclaimer because the court was very clear that that disclaimer really can help avoid potential liability. It's not a panacea. It doesn't automatically give you a lack of liability, but it is a very important piece to include. And then training is really important on social media use, on best practices, how to interact with social media, how to interact with members of the public. Social media is sort of a necessary evil at this point. Everyone is using it, and it is a great way to talk with your constituents. It's a great way to campaign, and you want to make sure that you are taking whatever steps are necessary to maintain that private status of your private pages, and that you have the ability to regulate the comments and other pieces underneath your social media. So those are some next steps. We have about 10 minutes left, and a bunch of questions have come in. So
Kristin,
Kristin, can I
Yes.
jump in? Go ahead, Gretchen. You
No,
started first.
I was going to say just a shameless plug on the board member training. I believe that CSBA provides governance training, which I imagine will incorporate this new standard, but F3 also Peter does quite a bit of governance training for school boards, and we do specifically social media training, and we do it virtually if anybody's interested.
Well, I was just going to say that boards generally will have a governance training almost always after an election when new board members come on, but some do it annually, where it really seems to focus primarily on Brown Act updates and Public Records Act and that kind of thing. And so I would just advise that whoever's doing that training include a module in that training on board member use of social media, because it is something that, especially if somebody's been a board member the last couple of years, they've been trained the wrong way. And so they need the new info, because I'm sure not all, however many thousands of board members there are in California are on this webinar right now. So having that reinforced in your district's governance workshops would be important.
We ready for questions?
Yes.
Okay, I have a personal page and I've had for years, and a trustee page I use to post about district issues. If I comment about a district issue under my personal account, is that a problem, like on a local Facebook page? So I understand this to be, they have a personal account and there's a page for the city that they live in, and they want to comment about a public issue under that account. What is that problematic?
I think that's what this case is all about, is recognizing that as a board member, you don't give up your First Amendment right and your interest and ability to comment on public issues. And so if this is truly their personal page and it's identified as a personal page, they still have the ability to comment on whether it's something happening at the city or something happening in their school district. Maybe so long as it's not information solely available through their personal Facebook page, but it's something they're either restating or opining on about their district business. I think it's gonna continue. It would not convert their personal page to a public page. But let me know if either of you disagree.
No, I don't disagree, and I'm thinking I would extend that possibly even all the way to the board member page as well. I think the board member would be able to comment using that page as well. So long as, and I would encourage them to have what I call a spiel. Typically when board members are, I won't say accosted, but when they're approached at a grocery store or a gas station or something, someone comes up to them to talk to them about a particular issue at a school or with the district. In my governance trainings, I always tell them to have a spiel, to say, thank you for sharing the information, acknowledge it, and then remind the individual sharing something with you that you are one of 5 or one of 7, and I don't have authority to address this on my own, but I will make sure that I get it to whoever the appropriate person is. And so I think that is good advice also on social media, especially if you're using your public official page to comment on things. It might be a good idea to explain either at the intro of who you are and your public official as kind of part of the disclaimer, or with each post to say, I'm one of 5. Thank you for sharing this information. Here's my thoughts as a member of the school board, but remember, I'm not speaking on behalf of the entire board. This is just my own personal voice as a board member, because what you're trying to avoid is creating the appearance that you're speaking on behalf of the board. And again, we have the 2-pronged test to see whether or not you actually are or can be held liable for doing so. But I think that's good advice, to have the spiel down, to be able to say, I'm one board member. Here's what I think about it, but I'm not speaking on behalf of the board.
For the next question, I'm just going to answer it really quickly. So the question is, so would all legislative bodies share similar outcomes of the 2 tests as school board member, city councils, board of supervisors, et cetera? And my answer to that is yes. This would apply to any elected official. We have a question from our own Josh Daniel. I think it's a good question. He says, I'm confused about how the post-by-post analysis would align with the decision to block someone, which is done once and is permanent. Say I block someone, but then a year later I post something that meets both tests. Do I have to unblock the person I blocked and then reblock them at some point later?
That's a really good question, Josh. And I don't know that we have an answer for that yet. the court says it's a post by post analysis, but they say that you don't give up that right. And so if you, I guess you'd create the presumption with the disclaimer, you create a heavy presumption that it's private. And then I guess if you do a post and you meet both tests, then I think there could be a problem. But as I mentioned before, I think it's going to be a very rare post by a school board member that's going to meet both tests. Unless it's maybe a board president, then you might. But by having the disclaimer, you've created a heavy presumption that the member of the public is going to have to overcome. So I'm not going to say that you'd have to unblock and then reblock. But I don't think we have a clear answer on that yet. And maybe we will once the 9th Circuit and the 6th Circuit both render their decisions on these cases that have been remanded to them on how this test is actually going to be applied in these cases.
Kristin, do you mind if we also read off the question about hate speech? Because I think
I'm going to. I'm just
Okay.
trying to go through and keep them in some sort of order. The question is, what if we have hate speech comments on our public pages? Can we remove hate speech? If so, how do we determine what qualifies as hate speech? And I will just note that we don't really have hate speech in the United States as a concept, but I think we understand what you mean by that.
Yeah, and I think it's an important question because there's certain types of speech that are not protected by the First Amendment that you can block regardless. So let's say you have an official district platform, either you're the board president or you're the superintendent or you're just managing the district social media. If there's a comment that is a threat of violence or is not protected First Amendment speech. So let's say it is it's racist or it attacks a protected class. It's attacking a gender identity or a nationality or someone's race. That is certainly not protected speech that you would have to leave up. Even if you had created a free speech forum, you would still be able to block a threat of violence or something, a post of that nature. Kristin, if you want to elaborate or feel free.
Yeah, I think that's correct, but I think that we just have to be careful because the question of how do we know whether it's, hate speech or not is the right question to ask. And if they're just being kind of snarky or criticizing the board member, that doesn't count. It would have to be something that's based on someone's protected classification. So it might be a time you want to reach out to legal counsel and double check.
Obscenities too. Sorry, I meant to mention that. Threats of violence and obscenities too.
Yeah, I think those are pretty clear-cut cases, but others you want to just be careful that the mere fact that something is critical or not nice isn't enough to remove the First Amendment protection. So it would have to be, as Gretchen says, a threat, obscenity, or some kind of protected class comment. We have a couple of questions about whether they can block members of or members of the public who are not members of their district community or who are not constituents. And I think it's important to be clear that these rules apply to anybody. It doesn't, the fact that someone isn't a constituent, isn't a member of your community, which we know you hear a lot from people who are not members of your community, might even live in other states because of kind of the current political climate, but there's no distinction. They all have the same First Amendment rights. So the same analysis would apply whether they live in your community or our constituents are not. We have some other questions and we have about 1 minute, so I want to make sure I'm respecting everybody's time. If there are some kind of hypothetical questions about, well, if I do this, then that. And I think just it's important to remember that these are fact by fact scenarios. And so without looking at your page, we can't really opine on whether you should, one thing is allowed versus another for your particular page. So I just think those are questions to have your superintendent ask legal counsel if you have very specific scenarios or things like that, because we want to avoid giving you information that is actually not correct without having had the ability to look at your specific pages. But there is one question that I think we talked about in preparing for this that I wanted to raise, and that is, what is the relationship between this case and these rules and requests for public records?
I'm happy to
Go ahead, Gretchen.
start on that. It's a very complex analysis. They're technically two different tests. And the challenge is there's a California Supreme Court case called the City of San Jose case that talks about the public's ability, that district records are defined as any type of district business, regardless of where you find it. So if it's on a board member's text messages or it's on their social media page, that can still be a public record for public purposes of the Public Records Act. You can have district business being conducted, which is a different standard as to when your social media page becomes a free speech forum.
I think this is yet to be fleshed out even more. And I really think this disclaimer that we've been recommending that creates the heavy presumption that this is personal and private may have some bearing in the future in the Public Records Act as well. Because if it's your private social media page and you don't have authority and you are not purporting to speak with authority, it's not a document that is being kept in the normal course of business by the public agency. I think there would be a pretty good argument to say, this isn't a public record. I mean, it's a social media page. People can look at it if they haven't been blocked, obviously. So it's there for people to see. I don't think I have a definitive answer. I just think there's some good arguments to make.
We have pending cases on this right now, and in part of the Public Records Act, district records include anything that's used by the district. So even if there was direct messages happening back and forth on Instagram, and they are actually about district business, those are still potentially public records. And so I just don't want to I don't want to mislead anybody that simply by putting a disclaimer and saying this is no longer an official page of the district and things like that, that you're shielding yourself from a Public Records Act request, because they're two different lines of legal analysis.
Really good point. And the instant messaging or direct messaging is different than a public facing post. But that's a really good point. It's like a text message, it's just in a different format.
So some folks have already left. We are over time. There are a few questions left. Peter and Gretchen, do you want to hang out and answer them, or?
A lot of them are that fact specific analysis.
Yeah.
I think it would be, I think both of all of our contact information is on here. I think if people want to reach out and we can help them walk through their specific fact pattern, it might be more helpful for them.
Okay, so why don't we go to the next slide that has our contact information on it? I think that's the next slide. Oh, sorry, should have done that slide. So all of our email addresses are on here. If you want to reach out because you have specific questions that we weren't able to get to today, we can leave that up for a little bit. And again, you will get the recording and the slides that will have this information on it as well.
It's not they didn't want to answer them. I just thought that there's a lot of follow-up questions.
Question, just one question that I know that we have gotten before, which I think is a real easy answer, is and it relates to what we hear in governance training, is can board members, does this change anything about board members liking or commenting on other board members' posts? And it doesn't change anything about the California law. In 2020, the Brown Act was updated and basically says, don't do that. This case doesn't impact that at all. So still, you should not be liking or commenting on fellow board members' posts.
Yeah, and one other thing I'd like to note too is there were some questions about responding to comments in other groups or on other pages and things like that. Be aware of that social media rule about responding to things by other board members, but also, if you are acting as a state actor and in responding to things like providing information that you are, have the authority to provide on behalf of the board, and you are purporting to exercise that authority, you've met the test, that's okay. It's what you do once you have engaged in that state action. So if you then block somebody, that is the problem. So you have the First Amendment right to comment on things and make statements, but just keep in mind that once you have then engaged in state action on behalf of your district, that's when you are restricted in how you can regulate how you interact with other people there. So there's kind of two different issues. This case doesn't prohibit you in any way from talking or engaging in statements. It's really, what liability are you creating for yourself when you go to regulate how you interact with other people? So hopefully we've given enough information for those of you that still have questions, but please don't hesitate to reach out to any of us if you would like to discuss further. Thanks everyone for being here today. Thank you so much, Peter and Gretchen, both for your great amicus brief and for being here today with us. We really appreciate it, and I hope everybody has a great weekend.
Thank you, Kristin.
Thank you.
Take care. Bye-bye.